Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing all about nationality, and in my today's class we are going to discuss what is double nationality or what is statelessness. As always, let us start the discussion with illustration, and then I am taking you guys to few important conventions as far as double nationality or stateless is concerned. Why to waste time? Let's get into the first slide. We know that double nationality or statelessness is an issue. Before even we start discussing any issues, let us try understand some ideal situations. Now imagine there is one Mr. A and there is one Miss B. Both are having the nationality of state A. Now, if they are getting married, they are getting the nationality of state A because they both are national of that particular country or state. Now, the second illustration, if they both are getting a child in the same state, in that case, there is no confusion on the nationality of child also, because both of them are belonging to that particular state and both of them are having the national of that particular state, and the child is also born in that particular state, so the child will also have the same national. So that is the ideal situation. And if we go out of the ideal situation, what happens, which is what we are going to discuss in my next slide. Now first let us discuss the issue of double nationality. When can double nationality happen? This can happen both in the case of marriage as well as newborn child. Now in marriage, for example, if a lady marries a man of a different state and if his state allows her to get the nationality on the basis of being his wife, and if her previous state also allows her to continue the nationality, in that case she gets double nationality. Just like that, there are few other illustrations I have given here. In the first illustration, there is a father who is of national A and mother is of national A, but they are living in country B, and if the child is born in country B and if country B allows to follow the jus soli rule and country A follows the jus sanguinis rule, in that case the child gets nationality of both the state and that ends in double nationality. Similar, you can continue with scenario 2 and 3 also, where the country where they reside follow jus soli, but if their original state allows them to follow jus sanguinis, then they end up, or the kid end up in getting double nationality. That is what you need to remember, and this doesn't happen when the theory of jus soli is followed in both the state. That means their original state and the state that they are residing. If both are following jus soli, in that case the double nationality theory will not happen. Or on the other hand, if both the state are following jus sanguinis also, the double nationality will not happen. Now see the image, understand my illustration, and then put different permutation combination to understand whether double nationality is possible or not. With that, I am moving to statelessness. Just like double nationality, statelessness can also happen in the case of marriage as well as newborn child. Imagine there is a lady who marries a different national person and she loses because she marries a different national person and her husband nation also doesn't give her any nationality. In that case, she becomes statelessness. Likewise, if Mr. A and B are coming from a particular state and if they are living in a different state, and if the different state where they got a child does not allow them to get nationality based on jus soli, and if their original state is not giving nationality on the basis of jus sanguinis, in that case that child also becomes statelessness. I have three different illustration. Please go through and do different permutation combination to understand whether the child will end up in statelessness. Now statelessness will not happen if the state is following jus soli where they are living, or if the original state follows the jus sanguinis theory. Now if any one of them happens, in that case statelessness will not happen. The most important international conventions as far as double nationality and nationality of married women is concerned is Hague Conference, which happened in the year 1930, which made an attempt to remove the difficulty arising out of the double nationality in the consequences of war, and which has a provisions in article 3 to 6 related to double nationality, and which also has article 5 which discusses about such a person shall be treated in their state as if he has only one nationality. the third state will either recognize the nationality which is more relevant in accordance with the fact and circumstances of each individual case. The Article 8 to 11 are very important as far as nationality of married women are concerned, which are saying an attempt has been made to remove the difficulties with the provisions of married women. This provision contained principally that if a woman marries, then she will automatically acquire the nationality of her husband, and in the recent times the Convention on Nationality of Married Women is yet another significant attempt to remove the difficulties and problems arise out of the double nationality. By seeing this convention, you can understand the difficulties which are being sorted with the help of double nationality as a consequence of war as well as marriage. So that's how we can understand double nationality and the approach of different conventions to resolve the issue. As far as statelessness is concerned, Convention on the Reduction of Statelessness, which happened in the year 1961, is the important convention which discusses about nationality shall be given either by birth or operation of law. And if in case a mother is married to a different state, in that case whatever nationality does mother have will be continued to the child also. And if anybody is losing nationality, it should be ensured that they are acquiring another nationality and then they lose in the case of marriage or divorce or termination of marriage, or in the case of adoption. And a person, if losing nationality, it should not end in statelessness. If somebody is losing nationality, that means they should have got some new nationality, only then that is possible. If somebody is losing nationality and becomes statelessness, in that case that losing nationality is not valid. And a person should not be deprived of nationality for reasons like departure, failure to register, or residence abroad. In these cases, if he or she has got already a new nationality, then only the nationality can be deprived. Otherwise, they cannot be made statelessness for these reasons. And acquiring a new nationality based on naturalization should ensure that nationality of new state is go first and then to lose the earlier nationality. It shouldn't be vice versa. That is the important thing you need to remember. One of the most important case law as far as being statelessness is Chakma's case 1961, which is of India's case, which is with related to Arunachal Pradesh and some community, which I am going to discuss in an independent video. And with that, I am ending this video also. I have to make few independent videos for the case laws that I have mentioned, and my next video will be on the differences between nationality and citizenship. Thank you so much. If you have subscribed my channel, please like, share and comment my videos. All the very best for whatsoever purpose you're watching me, and thanks again.